In this episode, we talk about a verdict by a sessions court on a case of discrimination on the basis of caste. We also talk about Canada introducing changes to its tourist visa policy. But first, we talk about the Supreme Court's judgment on the Madarsa Act 2004. Hi, I am Niharika Nanda, and you are listening to Three Things, the Indian Express news show. On 5th November, a three-judge bench of the Supreme Court, presided over by the Chief Justice of India, D.Y. Chandrachud, upheld the constitutional validity of the Uttar Pradesh Board of Madrasa Education Act 2004. In March, the Allahabad High Court had struck down the act, saying that it violated the principles of secularism. The Madrasa Act provides a legal framework for madrasa education, where along with the curriculum, religious education is imparted as well. To understand the Act in depth, why the Allahabad High Court struck it down and why the Supreme Court upheld its validity, we have Indian Express's Ajoy Sinha Karpuram joining us. Ajoy, can you tell us what is the Madrasa Act 2004?
So the 2004 Madrasa Act essentially provides a legal framework for how madrasas are supposed to function in Uttar Pradesh specifically. The main takeaway from the Act is that it creates the Uttar Pradesh Board of Madrasa Education, which prepares and prescribes course material, grants recognition to institutions, decides which institutions should receive funding, and conducts exams for all courses that are conducted in these institutions. The Act also gives the state government a certain amount of powers to create rules to regulate madrasa education. These powers are fairly broadly worded and basically allow the state government to, wherever it feels that there are necessary gaps, to be filled.
Right. And can you give us some basic statistics on how many madrasas exist, how many students are studying there?
So, during the hearings at the Supreme Court, the state of Uttar Pradesh submitted an affidavit on madrasas in UP specifically. And because UP has the most number of madrasas in the country, state by state. And according to the affidavit, there are about 13,364 madrasas that have either received some form of recognition or are being funded by the state government, though the number of madrasas being funded by the state government are significantly less than those that have received a recognition. Overall, there are about 12 lakh students, over 12 lakh students that study at these madrasas in Uttar Pradesh. At the national level, the Ministry of Minority Affairs in 2023 released some statistics in response to a question at the Rajya Sabha. They said that there were 19,965 recognized madrasas in the country, and over 3,648 that were not recognized. That being said, there are reports that these numbers are underreported, that unrecognized madrasas, especially in remote areas, might be an even larger number. But regardless, the largest number of these by far were in Uttar Pradesh as well.
Right, but Ajoy, after 2 decades of the Act functioning, why was it challenged and what were the grounds of it being challenged?
So the case actually starts not as a challenge to the Act, but with a part-time teacher at one of the madrasas who in 2019, from an institution in the district of Ambedkar Nagar in Uttar Pradesh, he argued that he should be made a regular teacher with the salary and service conditions that come with that regularization. While the case was in court, questions were raised about how madrasas function and how the madrasa board functions. Questions about how these board members are appointed, about whether the students were being denied proper education, as the madrasa board falls under the Minority Welfare Ministry and not the Education Ministry. So whether there were sort of gaps in the education being provided to students because of that. And the case was referred to a larger bench in 2023. And in the meantime, while the case was being referred around then, the Act was challenged by a lawyer practicing at the Allahabad High Court named Anshuman Singh Rathore. He argued that the Act violates the principles of secularism, which forms a part of the basic structure of the Constitution. What that means, I'll get into in a moment when I'm talking about the verdict. But yeah, he said it violates the principle of secularism, which is a part of the basic structure of the Constitution, and that the Act fails to ensure that students receive quality education, which violates the right to education under Article 21A of the Constitution. So that's where the challenge began.
So after the Act was challenged, what did the Allahabad High Court have to say?
So, on March 22nd this year, a bench of Justices Subhash Vidyarthi and Vivek Chaudhary struck down the act in its entirety. So, the case that was filed by the advocate Anshuman Singh Rathore was tagged with the larger case that was going on, and the court decided to hear that case. And the decision to strike down the act had three limbs of argument. There was the first and major reason, which was secularism. Referring to certain past cases, the High Court had held that secularism means equal treatment to all religions and religious sects and denominations by the state without either identifying itself with or favoring any particular religion, religious sect, or determination. So, running with that definition of secularism, the court found that in madrasas, it's compulsory for students to receive a certain amount of religious education, to learn about Islam as a religion and its prescriptions, instructions, philosophies. Whereas, quote-unquote, modern subjects like math and science were made optional or were completely absent. This, the High Court said, discriminated against students by not providing them secular education, and said that the government has a duty to provide secular education. That was the main reason the court struck down the act.
So, Ajoy, this was the main reason. What were some of the other reasons given by the Allahabad High Court?
The other reasons were the fact that under Article 21A, which is the right to education, they said that the government was violating this right by denying quality education to these students in modern subjects. One of the things the court said, and this is an exact quote, is the state cannot hide behind the lame excuse that it is fulfilling its duty by providing traditional education on a nominal fee. But the High Court said this was not enough, that it's not enough to provide close to free education, it also has to be quality education. Then the High Court also had a problem with the fact that under the Madarsa Act, the Madrasa Board was given the power to grant certain degrees, including higher education degrees. Fazil and Kamil, which is the equivalent to a undergraduate and postgraduate degree, the Madrasa Board was empowered to give these degrees under the Act. But the High Court said that the University Grants Commission Act, which is a central law, covers the field in this sense. The only universities that are either deemed to be universities by the UGC or universities that were created under a central or state law are allowed to grant degrees under Section 3 of the UGC Act. So the High Court said that there is a conflict there between the Madrasa Act and the UGC Act, and gave precedence to the UGC Act in that sense. So based on these three reasons, the High Court said that the Madrasa Act from 2004 had to be completely struck down.
And then the case went to the Supreme Court. So what kind of a debate was held over the act in the Supreme Court?
So one of the first things that happened at the Supreme Court after the decision from the High Court came in March, in April, the Supreme Court stayed that High Court verdict, basically staying its functioning. The act was allowed to survive while the case was being heard. But then while that case was pending at the Supreme Court, the National Commission for the Protection of Child Rights issued two communications on June 7th and June 25th. These communications directed the UP government to investigate madrasas, recognize madrasas, and admit non-Muslim students from these madrasas to schools where formal education was being provided, and requested all states and union territories to inspect madrasas as well and withdraw recognition from those that were not complying with the Right to Education Act. And these notifications were later stayed in October 2024. And before the court, the NCPCR wasn't pleaded as a party, and they took a strong stance, arguing that madrasas were imparting religious instruction to students as a substitute for quality secular education. Other advocates who were also challenging the act said that the Madrasa Act does not have any provisions to give quality education, and that the students were sort of barred from entering the mainstream if they attended these institutions. The petitioners that challenged the High Court's decision offered some resistance to this argument, arguing that madrasas do in fact offer education in basic subjects like math and science in accordance with the NCERT curriculum that most schools follow, and that the Madrasa Board decides the curriculum which restrains the madrasas themselves from choosing not to teach certain subjects. So the petitioners argued that there was a level of oversight here.
Right, and another major point that was discussed in the Supreme Court was that the High Court had struck down the act in its entirety and not just bits or parts of it. So, was that necessary?
The Chief Justice of India himself, D.Y. Chandrachud, said during the hearings to throw out the act is to throw out the baby with the bathwater, and noted on a number of occasions that if there were shortcomings in the education provided at madrasas, the act contains a host of provisions to fill those gaps, to make up those shortcomings. If there were subjects that weren't being taught, the state government has the power to come in and pass rules that say that madrasas should teach these subjects. So bench sort of questioned that notion that there was no movement on the status quo. And yeah, that was basically what the discussion in the court was about.
Right. And Ajoy, on what grounds did the Supreme Court validate the Madarsa Act? And what was the Supreme Court's detailed verdict?
The court had a couple of main reasons for reviving the act. The first one being on this argument of secularism. The court said that the argument that madrasas violate the principle of secularism, which is a part of the basic structure of the constitution, did not necessarily hold a lot of weight. In order to make that argument, you have to say it violates the basic structure and then point to a specific provision of the constitution that is being violated in this process. The decision said that for a law to be struck down for violating the principle of secularism, it must be traced to an express provision in the constitution. It must be traced to one of the articles in the constitution. And it did not meet that standard in this case. The other thing that the Supreme Court said was that the state has an interest in regulating madrasas and regulating education that's being imparted at these institutions, and that the state has the power to make sure that these institutions are functioning at a level that provides quality education without violating the rights of these minority institutions to handle their own administration, which is a right they have under Article 30. So as long as the states provide reasonable and rational regulations, they can sort of urge these institutions or push these institutions towards providing quality education. And the court held that the Madarsa Act does this without depriving educational institutions of their minority character. Madrasas, Vedic pathshalas, and educational institutions that primarily impart religious instruction are exempt from the RTE Act entirely. The Right to Education Act does not apply to these sorts of institutions. This was affirmed in a 2014 case at the Supreme Court. So the Supreme Court referred to both the RTE Act and this decision and said that the High Court had erred or made a mistake by striking down the law for violating the right to education.
Right. And along with that, the Supreme Court also affirmed the state's power to regulate the functioning of educational institutions, along with the institutions that impart religious knowledge. However, there was this one part of the act that the court didn't revive. Can you tell us what that was?
The one thing that the court didn't revive was the bit on granting higher education degrees. It was this, specifically the 2 degrees of Fazil and Kamil. The court said that the UGC Act in fact does cover that field, and that only institutions that have been deemed to be universities or other recognized universities under different central and state laws could grant degrees at a university level. So there were a couple of provisions in Section 9 that allowed the Madrasa Board to grant degrees at the undergraduate and postgraduate level under the Fazil and Kamil names respectively. Those have now been removed from the Act entirely.
And Ajoy, what is the way forward? How do we see this Act proceeding from here?
One of the things that will have to come out of this with this higher education question, with the fact that the Madrasa Board can no longer grant these degrees, is that there are currently thousands of students in Uttar Pradesh who are pursuing these degrees. So the question of what happens to them and what happens to the degrees that they're pursuing is up in the air a little bit. It will be up to the state government, the center, and the UGC to see if this power can be granted to certain institutions to grant these degrees. There was a little movement in 2014 when the UGC, through a notification, recognized the names Fazil and Kamil as valid names for degrees that could be granted under the UGC Act, and also gave some clarity on the number of years that need to be completed to receive these degrees and the minimum qualification you need to pursue these degrees. But there currently isn't a lot of clarity on which institutions can grant these degrees, in Uttar Pradesh at least, with the board's powers to grant higher education degrees being removed. That being said, the decision does still come as a relief for the over 12 lakh students in Uttar Pradesh receiving education at madrasas.
Next, we talk about another judgment, except this one was given by a sessions court. Last month, a sessions court in Karnataka gave a verdict on an incident that had happened in 2014. It was a case which dealt with discrimination and assault on the basis of caste, where members of the Dalit community had faced the wrath of the people from the upper caste due to a conflict that happened between the two communities.
A Koppal District and Sessions Court in Karnataka gave an historic judgment where it sentenced 101 people in a riot case that took place in 2014. Out of this 101 accused who were convicted, 98 of them received a life imprisonment sentence.
That's Indian Express's Kiran Parashar. In this segment, Kiran explains to us what the conflict was, what led to this judgment, and how discrimination on the basis of caste and untouchability are still in practice. Kiran, can you explain to us what happened in the Marukumbi village in Karnataka in 2014?
Niharika, I'll take you back to 2014, the case. So in 2014, on August 29th, the incident unfolded outside the village where there was a screening of a movie, and some of the villagers had also gone to watch the movie. So one person belonging to Bovi community. So Bovi community is also listed as a scheduled caste community in Karnataka. So one person from Bovi community was assaulted by Dalits belonging to a different village. So this became a triggering point, and that Bovi community guy came back to the village, and then he informed the other heads of the village. So these people attacked the Dalit colonies there, and 3 houses were burnt, and some women were dragged out of the houses, and they were also assaulted, and nearly 30 people were injured. So right after the incident, it became a big issue in Karnataka, and a lot of people started questioning the police over their negligence over this case because of the atrocities that were carried out against Madigas of that village. So soon after that, more than 100 people were arrested in the case, and after the arrest, they spent 48 days in jail. So after 48 days in jail, they got bail from the Karnataka High Court Dharwad bench. So after the bail, they returned back to the village. Many of the villagers thought that 48 days was the punishment for the crime that had taken place. As the case went on, what happened was the court finally concluded it not as a mob violence, but it was a case of where caste discrimination and atrocity, and the court ordered life imprisonment for the people belonging to the upper caste of that specific village, and they were convicted.
And can you tell us a little bit about this village in question, Marukumbi?
Niharika, so Marukumbi village, which we are speaking about, is a very small village in the Koppal district. It is 12 kilometers far from Gangavati, which is a taluk. So this village has a population of 1,774 to be very precise, which comprises of Dalits. Dalits in the sense, here you have to take it as Madigas, Muslims, scheduled tribes, Lingayats, and Bovi community, and other people. It's a straight road where in the right side of the lane, you will see Madigas houses, that is Dalits houses. On the left side, you will see the houses of other people. Usually the Madigas or the Dalits doesn't enter this side of the road, and the upper caste people doesn't go to the other side of the road.
So how has this incident affected the village?
So of this 1,774 people living in this village, if you see, there are about 150 to 200 houses. So when the judgment came from the upper caste areas, at least one person from a house was convicted in that crime. To just give you an idea of how it was, so there are houses where 4 to 5 people, male members of the family, were convicted. So it came as a shocker for the villagers, because before the sentence that was ordered by the court, 2 days before, the conviction had come out, but the villagers, many of the villagers are uneducated here and are dependent on farming. It's a big farming community. So most of the people didn't know that they were convicted because of this crime. So police used a trick, saying that they have to come to the court just to sign so that the case would end, because it would be a law and order problem if the entire police force go to a village and bring all those 101 people who were convicted in the crime. So everybody thought that this was end of the case and they went to the court just to sign. That is when they realized that they were convicted. Just to tell you, like when the judgment came out, so basically life imprisonment in Kannada, you call it as Jivavadi Shikshe. So many of the villagers didn't even know what Jivavadi Shikshe or life imprisonment means. So that's the kind of knowledge about the law the people have.
Right. And to what extent is the caste system and untouchability still prevalent in the village a decade later?
Speaking about the history of caste atrocities in this region, so the discrimination, untouchability and all these things are still being practiced, Niharika. It is not the first time. This is probably like the second or third time that I am visiting Koppal district, specifically to report about the untouchability practice. If you can recall, a couple of years ago, in the same district, a family of a 3-year-old child was fined rupees 25,000 for allowing that Dalit to enter, as the child had entered the temple. It's a Dalit child. It had entered a temple. So the village had penalized the family with 25,000 because they wanted to clean the temple as the child had entered the temple. So the caste system and untouchability practice is very much prevalent in these regions. The major victims in this region is again the scheduled caste. Most of the people in this village, a lot of upper caste community people hold a lot of agricultural lands. So in these agricultural lands, Madigas go and work there. So when this incident happened in 2014, for the next 2-3 years, according to the people who I spoke, so Madigas were not hired for labor works, and people did not even allow them to enter inside the restaurants or hotels or even barber shops, and they were not even allowed to buy groceries in the shops belonging to the upper community. No Dalit had a grocery shop then. So these people had to travel 12 kilometers back to Gangavati to buy all these things. This was the situation according to the Dalits in the village whom I spoke to.
Right. And Kiran, what do the people of the Madiga community or the Dalit community of the village have to say about this verdict?
So if you go to the village, there is one mood common in both the sides. That is fear, Niharika. So if you go to the areas where upper caste people live, you will see a lot of fear and anxiety among those people, because you can imagine that out of 150 odd or 200 houses, at least from each house, one male member has been picked up. And many of them are more than 50 years of age. And some of them are in their 30s or 40s. So there is a kind of fear among those people. And when you come to the lanes of where Madigas live, the Dalits live, you will see a mood of justice that they have got. There is a sense of relief that they feel that they have got justice from the court, but at the same time, they are also fear their future, because most of the Dalits work in the lands of this upper caste community, and all these people have been arrested. So for them, it is a hope at the justice, hope, and at the same time, there is a fear of what next, because if there is a kind of financial boycott, if at all it is done, then these families may go into big trouble. So that's how the situation is now.
And what kind of a reaction did the verdict receive from the upper caste people of the village?
When I visited this village, what I found was that many of the people from the village, the male members of these houses, were taken by the police and they were sent to various prisons because of the prison population problem and all. So they were sent to various prisons in the region. So in many of the houses, there were no male members at all. It was only the women who were waiting. And these men who were convicted and who were not aware that they would be sentenced for a life imprisonment, they had informed their family members, the women in their family, that the case would end and they would return back by evening or next day. And they had went in tractors, and some people went in groups. So it came as a shocker for the families as well. And as it's a farming community, they're expecting an yield. And at this point of time, all these people were taken into custody because the court convicted them for the crime. When I met the villagers, the families of upper caste community, what they said was that the lawyer who was handling the case was not explaining them or was not sharing about the case updates. But the defense counsel who represented the convicts, Umesh Malekopa, he said that he was in touch with all the accused, and he said that he will challenge the verdict in Karnataka High Court.
But Kiran, do we see the situation between the different castes improving in the village and in the area as a whole?
I also asked that usually were there any compromise attempts. So one of the Dalits, Basuraj, his name is Basuraj, he told that there were a couple of attempts to compromise. So one was that according to Basuraj, the upper community caste people thought that these people may withdraw the case when the boycott was done. So when they fought against it successfully and they went ahead and going to Gangavati 12 kilometers to buy groceries and all these things. This year in February, the upper caste residents organized and celebrated a temple fair. That temple is located in Madiga area. So till date, the upper caste community had never visited those temples. It was only Madiga people who used to celebrate the temple fair. But this time those people also came. And during the planning and the meeting for the festival, there was a word asking to withdraw the case. However, the Madiga community people told that let the law take its own course and let's not talk about these things when we are meeting here to talk about the temple fair. As we speak, they don't know what's ahead of them.
And in the end, we talk about Canada. Canada has introduced changes to its tourist visa policy, scaling back its once standard practice of issuing 10-year multiple entry visas. The revised guidelines allow immigration officers more discretion in determining visa types and validity, meaning frequent travelers may no longer be guaranteed long-term access. Immigration, Refugees and Citizenship Canada IRCC said that while multiple entry visas with maximum validity were previously the norm, officers will now assess each applicant individually, potentially issuing shorter visas based on the need. The updated guidance reflects a shift in Canada's approach to temporary immigration driven by rising housing shortages and cost of living concerns. Frequent travelers to Canada could face increased costs and logistical challenges under the new policy, as they may need to apply for visas more frequently. The government hopes that these measures will help manage immigration levels amidst concerns about rising number of temporary residents. IRCC stated, quote, "Guidance has been updated to indicate that multiple entry visas issued to maximum validity are no longer considered to be standard document. Officers may exercise their judgment in deciding whether to issue a single or multiple entry visa and in determining the validity period." Unquote. You were listening to 3 Things by the Indian Express. Today's show was edited and mixed by Suresh Pawar and produced by me, Niharika Nanda. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it. Share it with a friend or someone in your family. It's the best way for people to get to know about us. You can also tweet us at Express Audio and write to us at podcasts@indianexpress.com.